All right. Hello, class. My name is Robert Kaczynski. I'm sorry I can't be with you in person. Uh, these crazy times are forcing us to do much more online. But anyway, I'm glad that Joe asked me to talk to you, and I'm happy to do that. My understanding is, are these all students who are going into are thinking about going into the criminal justice system, Joe?
Mm-hmm.
All right, so
Excuse me.
my understanding is that you all are interested in pursuing a career one way or the other in the criminal justice system. And I'll tell you a little bit about what we do here. We have, you're obviously in courtroom one here. I'm what's called a circuit court judge. Circuit court judges are general jurisdiction judges. And so what we deal with is we deal with all the felonies. We deal with juvenile matters, we deal with abuse and neglect matters, we deal with all kinds of civil matters. And then we have, there's 8 of us in this circuit, the 7th Circuit, to deal with that. Then we also have magistrate judges, and we have 4 magistrate judges in our circuit, and the magistrate judges deal with all the misdemeanor, traffic offenses, small claims court, and so on. So we have, with respect to felony cases, magistrates are always the judges that see felony cases first before they come up to circuit court for their initial appearance, or what we call an arraignment. So that is essentially what we do. But my understanding is that the focus of this particular presentation is with respect to what we do with the juvenile justice system. The juvenile justice system, I think, is probably one of the more important things that we deal with as judges. And quite frankly, I think it's one of the more important things that anybody in the criminal justice deals with. That is all the way from law enforcement to court services officers to people like Joe, who run the Juvenile Services Center, to the people who run the Rice facility, which is where some of the juveniles, if they're low-risk offenders, end up going. It's a little bit less restrictive than the Juvenile Services Center. So in my opinion, it's one of the more important things that we do in the court system. The juvenile system, the way that we proceed is very similar to the way that we proceed with felonies, with some major exceptions, and I'll go through those with you. First of all, juveniles are entitled to private hearings. So any hearing that we have in court, and this courtroom we use for juvenile hearings, we have a bailiff that's normally at the door, and the bailiffs make sure that there's nobody in the courtroom who doesn't have to be with respect to each juvenile's case. Juveniles are advised of their rights. They have very similar rights to adult offenders, with the main exception that they're not entitled to a jury trial. But the penalties associated with a juvenile offense are significantly less. Essentially, the biggest hammer that we have over juveniles is that they can be in our custody until turning 21 years old, whereas with adult offenders, obviously, anything up to the life sentence and potentially the death penalty is something that is on the table for certain offenses. Juveniles don't get a jury trial, but if they contest the allegations against them, then we have a court trial, and the state still has to prove the allegations beyond a reasonable doubt before a juvenile can be adjudicated as delinquent. And the main difference is that we don't have a jury, but I, as the judge, will decide whether the state has proven its case beyond a reasonable doubt. Of course, juveniles, just like adults, are entitled to be represented by competent legal counsel. And I have to say that most of the lawyers that we have representing juveniles are fantastic. Their heart is really in it, and they really care about the people that they're doing work for. Once a juvenile is adjudicated as delinquent, we have court services becomes involved, and they give me a report. Sometimes it's just a dispositional summary. If it's a non-minor type, if it's a minor type offense, although all offenses are bad, but if it's not a very serious offense and the juvenile is eligible for probation, then we generally just get a quick summary of the juvenile with a recommendation. If it's a more serious offense that could implicate the Department of Corrections, then we get what's called a social case study prior to determining what should happen to a juvenile. Juveniles that are put on probation are put on probation for a period of 4 months. Juveniles who are put into the custody of the Department of Corrections may be there until they turn 21, depending on how well they are progressing. A lot of times, juveniles who are sentenced to Department of Corrections custody will be sent out of state because we don't, unfortunately, have enough programs for juveniles within our state, and some of them will go as far as Georgia to seek treatment. And once they're better, they come back into the community. They're still generally under the supervision of the Department of Corrections until they're discharged. So that is kind of a bird's eye view of the juvenile justice system. Joe, do you have any particular questions you want to ask me?
So what is the difference between a detention hearing and other hearings that we have in the juvenile system? So detention hearings, can you talk about what that is?
Sure, I'm glad you asked that. So what I started out with when I described the flow of a juvenile case through the court system, I started with the juvenile's initial appearance before the court where they're advised of their rights. However, with juveniles, before we even get to that point, if a juvenile is taken into custody for an offense, by law, juveniles are required to have a hearing within 48 hours to determine their custody status. In other words, should the juvenile continue in JSC? Should the juvenile be released to the custody of a parent, a relative? Should the juvenile be placed in a RISE? And so it's a very important hearing. By law, it's supposed to happen within 48 hours of the juvenile's detention. However, we in the Seventh Circuit do it within 24 hours. So we essentially have juvenile hearings every day if need be. And at a juvenile detention hearing, generally we appoint a lawyer to represent the juvenile. Generally the parents appear. If the juvenile is in the custody of their parents, then generally they will be in the courtroom. If the juvenile is still at the juvenile detention center or juvenile services center, or at a RISE, the juvenile will appear by phone. And so at that point, the judge will hear what happened. The state will advise the judge of the offense that the juvenile has committed. And the judge then listens to the defense lawyer, listens to the juvenile, listens to the parents, and the judge then makes a decision whether the juvenile should be held until the case progresses.
Can a juvenile be charged as an adult, and what are the criteria?
Yes, a juvenile can definitely be charged as an adult, and you're putting me on the spot. It's been a while since I've judged juvenile cases. I believe any juvenile over the age of 16 who commits a adult offense can be charged. Certain adult offenses, serious adult offenses, can be charged as an adult. All juveniles can be charged as an adult subject to a transfer hearing. So if a juvenile is younger than 16, the state may consider the offense to be so serious that they ask for a transfer hearing. And at a transfer hearing, the court will listen to the evidence and determine whether or not the juvenile should be charged in adult court. With a juvenile who's over the age of 16 and is charged in adult court from the beginning, the defense can request a transfer hearing back to juvenile court. And so it's really the same type of hearing. I'll hear the evidence, and I'll then determine whether or not it is in the best interest of the community, society, and the juvenile for the juvenile to proceed in adult court or juvenile court. But in both instances, it's a transfer hearing. It just depends on whether the juvenile goes to adult court or down from adult court to juvenile court. But don't hold me to the age of 16. It might be 14, or is it 16? It's 16, Joe tells me. It's been a while since I've done that.
How long can you sentence a juvenile to the juvenile services center?
So a juvenile may be sentenced to the Juvenile Services Center until he or she reaches the age of 21.
Okay, when you give a sentence out, what is the longest term you can give a sentence as a judge? Can you give them 60 days, 90 days, or how many?
Oh, you're talking about if it's a probationary
Yeah.
sentence with jail. That's a good question. I forgot the maximum sentence.
Okay.
Is it, I believe it's 90 days, isn't it, Joe?
90 days.
Yeah, so 90 days is the maximum sentence. I'd have to look at the rules again. I believe if it's anything above 14 days, there's got to be a really good reason for it, and the court has to state its reason on the record.
What are some of the challenging types of offenses that you've seen that you've had to preside over?
Well, they're all challenging, to be quite honest, because you've got this young person in front of you, and the whole point behind juvenile court is to try to rehabilitate the juvenile. We try to do absolutely everything we can to make sure that the juvenile doesn't end up in adult court. This is the time for us to try to see if we can correct some of the behavior, correct the environment that the juvenile lives in, and try to make sure that the juvenile becomes a productive, law-abiding citizen and stays out of adult court. So the problem that we have is, the reason why I say that all these cases are challenging is you could start out with somebody who commits absolutely, totally minor offenses. So in some counties, these minor offenses are charged not even in a formal petition. They're charged as a ticket, like, for example, intoxication. Well, I don't want to downplay it. I think it's a serious offense, but on the scale of what we do, it's fairly minor. But it can lead to more serious offenses. And so you try to kind of nip it in the bud right from the beginning. You try to make sure that the juvenile doesn't do that. And then, of course, you see the very serious offenses. Murder. You see murder cases. A lot of juveniles who commit murder are charged as adults, or if they're below the age of 16, are moved to adult court following a transfer hearing. Of course, if they move to adult court, they're the objectives of the penal system are a little bit different than for juveniles. But what you really try to do is, as hard as you can, you try to make sure that you steer this juvenile in the right direction so that you never see the juvenile again. And so the most frustrating cases, not the worst cases, but the most frustrating cases that we see are the substance abuse cases, especially when it comes to methamphetamines, because it's such a very difficult drug to kick. And it's very difficult to deal with juveniles who come in here and are addicted to methamphetamines. The cases that start with marijuana are very, very difficult because there are so many states that now allow it. And granted, none allow it for juveniles, but a lot of juveniles kind of take that as a clue, thinking that it's okay to do that. And of course, they get hooked on that, and it's a very difficult drug to kick. And it totally, especially with juveniles, it's so dangerous because it totally changes their brain chemistry, and it changes their growth pattern. And it really affects kids for the rest of their life if they start with marijuana from an early age. And unfortunately, we see marijuana, I should add, the youngest age that a juvenile can come into juvenile court is age 10. So any offenses committed before age 10 are not offenses. If it's committed at age 10, it's a juvenile offense potentially. And we see kids who are 10 years old who come in here on marijuana offenses, and then we learn that they actually started smoking marijuana at age 7 or 8. And that's really disheartening, and it's troubling, and it's difficult.
What does the term parens patriae mean?
Parens patriae essentially is substituting the state for the parents. So in other words, when the state steps in a parental role to kids, that is what parens patriae means.
If you have a juvenile that's coming to court, what would you like them to know about procedures, dress-wise, attitude-wise? What advice would you give a juvenile that was coming to court?
Well, if you sit here long enough, well, first of all, everybody should dress appropriately. So don't come in with a tank top, don't come in with shorts or flip-flops if it's summertime. Try to dress long pants. I know that, it's difficult. Some of these families that these juveniles come from don't have a lot of means, and a lot of times they don't have a lot of clothing to choose from. But almost everybody has a long set of pants and maybe a t-shirt as opposed to a tank top. A shirt is preferred, long sleeves is preferred. But I will tell you, you see some of these kids that come in dressed like that, and you know exactly why they're doing it because they're trying to correct their behavior. They're doing it to impress the judge. So most of all, this gets back to attitude. I'd like the juveniles that come in front of me to start thinking about the offense that they committed and where they want to go with their lives. Their attitude is much more important to me than their dress code. And don't chew gum when you come in, please.
Most of the kids in our class are in the law enforcement track, and sometimes law enforcement have to come to court. What advice would you give professionals in the criminal justice field that have to go to court about the same thing, dress and behavior?
This applies to whether or not you're appearing on a juvenile case or an adult case. First of all, know your case. It is extremely important. It doesn't happen very often, but every once in a while you get a law enforcement officer that comes in here for a hearing, whether it's a suppression hearing or other type of motion, sometimes for a sentencing hearing, and they didn't look at their own report. Pull out your report, read it, know it, read it 2-3 times, study it. It is so important that you know your case, and you can really tell those officers that have taken the time to study their report versus the one that just kind of decided they're going to come in here and wing it. Now the good news is that almost never happens. In my 7 years on the bench, it's happened less than a handful of times. So that is great news. I believe that all law enforcement officers that we have in our jurisdiction are very professional and take their job very seriously. So that's the first thing. Second thing is dress appropriately. That's never really an issue because most law enforcement agents simply come in their uniforms, and that's perfectly fine. Third, answer the questions. Don't try to be smart about your answers. When the prosecutor asks a question, just answer the question. Don't worry about the consequences of the answer. Just make sure it's a truthful answer. Where I see a lot of law enforcement officers get themselves in trouble when they're testifying is when they're being cross-examined by the defense and they try to think ahead of what the defense is trying to do, where they're trying to go, and they are trying to try to help the prosecutor in not getting there. Just answer the question. It's the prosecutor's job to convince the court. Your job is to simply be truthful. And I've never seen a law enforcement officer get in trouble or their case get in trouble with them simply being truthful, even if the particular answer isn't very good for the case. Don't worry about it. You are here to tell the truth, and that's it. No more, no less.
Judge, can you tell us a little bit of how you got into this field and what your background is?
Yeah, I made a big mistake. So I actually started in the engineering field. I went to school and I was an engineering student in Arizona, and I graduated with a bachelor in aeronautical engineering. I also was a pilot during that time, and so I worked for regional airlines, commuter airlines, the United Express carrier, and ended up here in Rapid City, and had some medical issues and decided, well, I can't keep flying for the rest of my life. So I didn't know what to do. I decided to go to law school. So that's how I ended up in law school. I worked in private practice for quite some time, and then I took a position with the U.S. Attorney's Office, the Federal Prosecutor's Office. I worked in their civil division for a while, and then I was lucky enough to have the governor appoint me to a judgeship. So that was my track. I would say a lot of people know whether or not, I mean, a lot of people know that they want to be lawyers. A fairly good percentage of judges that become judges always known that they wanted to become a judge. I think that's probably true with me as well. But it's a matter of timing, getting enough experience, and being in the right place at the right time.
What advice would you give a young criminal justice student about their careers looking forward?
Well, I quite frankly, I think a career in criminal justice is fantastic. And when you really think about it, a career in criminal justice isn't just being a law enforcement officer. There's just a whole wide range of fields and areas you can go to. I mean, you could obviously go to law school and become a lawyer and work the criminal justice system, either as a prosecutor, defense lawyer, or as a judge. You can also be in corrections, and there you can be in adult corrections or juvenile corrections, and that's a hugely important position. You can go into court services. Those are, you know, what we refer to generally as probation officers. They do a great job, and they're on the front lines of trying to help both juvenile and adult offenders while they're on probation. You can become, obviously, a police officer, and within the actual traditional law enforcement field, there are all kinds of opportunities, whether it's state, federal police work that you're interested in, and there are all kinds of areas in law enforcement that you can go into, from violent offenses, drug offenses, offenses against property. You can go into white collar type offenses. So it's just a huge field that you can become involved in. And then there are some ancillary fields that you can start thinking about. For example, Department of Social Services, Child Protective Services. You know, those are the people that help us with abuse and neglect cases. And while abuse and neglect cases are purely civil cases, they still have a lot of aspects that involve law enforcement type issues. And so it's just a wide open field. I think it's a rewarding field. When I talk to law enforcement officers in all these areas that I just mentioned, they're all hugely gratified by the work that they do, and it's a chance to serve the public and your community and do some good.
My last question, what is a magistrate judge?
Oh, a magistrate judge, they're actually the hardest working judges in the system. So I think I started out by saying I'm a circuit court judge. We are what's called general jurisdiction judges. So think of it in terms of we have jurisdiction over all cases, period. So we can do all cases. Magistrate judges, they're not appointed by the governor and they're not up for election. They're hired by the presiding judge of each circuit for a 4-year term. And magistrate judges have limited jurisdiction. So where a circuit court judge can do any case, including cases that magistrates do, a magistrate judge can only do certain cases. And in South Dakota, a magistrate case load is limited to misdemeanors, petty offenses, traffic type offenses, small claims court, certain cases that involve